Good morning. Today is Sunday, May 31st. I thought I'd put up a brief summary of the Chapter 1 material for your consideration and review. I'm going to focus on only what I consider the key portions of the text. The book is pretty well written, and I think Chapter 1 is one of the easier chapters to digest, but nonetheless, I think some of you will benefit from having a sort of a video discussion or review from me. And I like to go through the material as well because I can kind of hone in on what I think is testable material, and I think that would most benefit you to understand. Chapter 1 is basically a backdrop that you'd get in almost any legal course or any law course, talking about the sources of law and what is law and our judicial system. That's especially true in Chapter 2 when we get into jurisdiction. But in Chapter 1, it defines a law. And I always like to do this in class when I define law, because we all have an intuitive sense of what it means. But when somebody tries to make you articulate what it is, it can be a little bit of a challenge. But my interpretation or my definition is law is that standard or set of rules in which the government is willing to enforce with sanction or reward. If the government doesn't have a sanction for prohibited conduct or for required conduct, it's really not a law at all, because the abidance of the principle wouldn't have ramifications. It might be an ethical standard, it might be a moral standard, but it's not a law. And many of us have moments in time in life where someone says, hey, you have to do this or you have to do that. And when we question it, often the answer is the law requires it. And I'm not asking anybody to be a rebel or an authoritarian rejectionist, but I sometimes find myself saying, well, what law? Where? And the textbook tries to outline the major sources of law. So we know that outside of that spectrum, some things that we might believe we must do or not do might not necessarily be true because it's not embodied in a law. Maybe we should do it or not do it because it's ethically or morally appropriate, but it's not necessarily law. So starting off with the definition of what is law, especially business law, it's those standards and rules in which the government is willing to enforce via a sanction, penalty, or some form of punishment if not followed. In business, it's going to be focused mostly on transactional law or those things related to commercial or even individual legal obligations through transactions. And we're going to focus on that once we get to Chapter 5. So why do we have it? Well, we have to have a society that has some sort of predictability. If we know or have the ability to know what the laws are, we'll know the ramifications of our conduct. We'll know if we're in a binding agreement. We'll know if there's going to be sanctions to the opposing party if they should breach it. So if there is, we don't want to have to go and resolve these disputes with baseball bats and force. We want to have a civil society where we can take these principles to a court of law if need be and apply the legal principles to have a civil result is something that is predictable and something that is done without violence, and it's done to make society run somewhat more smoothly. The book gets into the roots of our legal system. I think that's very important, but I don't know how testable it is, and I don't know how critical it is to a business law class. But the roots of our legal system obviously come from the colonial era, and we had different colonial influences. The book mentions the English, the French, and the Spanish. We've had others actually too. Certainly the Dutch and Portugal had influences during the colonial period of time. So they were very broad-based, but the colonies actually became dominated at one point by the English common law system. What is common law? Common law are a bunch of principles that basically the English courts and the English authorities adopted as part of their legal system, saying these customs that have been long-standing in our nation and with our people will now be embodied as legal principles. That's interesting and it's fascinating, and I'd like to talk about it in a different course maybe. But for this course, when you hear the word common law, I want you to concentrate on the principle of court-made law. Although our courts aren't really designed, at least at first blush, to be creators of law, they do interpret law on the appellate level. So sometimes you'll have a legal principle being debated. What does this legal term or principle mean? We'll dispute it at the trial court. The trial judge will make a ruling on what it means, and one party might appeal it, or both parties might appeal it. When the appellate court makes a ruling establishing a rule of law definition or what it means or interpretation, that creates a principle. That principle will now be followed in future cases at the trial court level that have similar fact patterns in the same legal question being asked. That's setting the principle or the precedent. And you've probably heard that term before. What term you might not have heard before, and it's on the quiz, and I know many of you are worried about doing well on the quiz, it's called stare decisis. Stare decisis is the Latin term. I think it translates roughly to let the matter stand. Once these principles are established by our court system, the appellate court system or higher, these principles will be applied in the future unless later overturned. And that's rarer than not. We tend to follow legal principles once established long into the future to give predictability to our legal system. So we know in our current conflict what's likely to happen based on previous court decisions. And it also gives us confidence in the legal system that I'll be treated the same as some predecessor was under the legal interpretations. So that's what I want you to know about the common law more than anything else. Equity is mentioned in the first chapter. Equity is simply a system of remedying a legal problem other than money. Family law is a very big area of equity law because people aren't always looking for money in a divorce. They're often looking for child custody or visitation rights or things like that, or an injunction, which we call a protective restraining order, perhaps, to keep someone from contacting you or staying away from you. That's an equitable form of relief. The way the book defines it, and this is a classic definition, is getting that form of relief from the court system other than money. And it's to give results that justice really requires without sight of a rigid monetary formula. We do deal with some equitable relief in business law. Sometimes we seek an injunction against someone from doing something, or something called a mandamus. I don't even think your book mentions mandamus. I don't think I mention anywhere any kind of test. But a mandamus is requiring someone to do something. So when you see equity, you know it's something other than seeking monetary damages. Sources of law, this is really what I want to hit more than anything else from Chapter 1. We have 4 primary sources of law. There are others. What are they? Well, one is the supreme law of the land. That's the Constitution. But we have 51 constitutions. We have state constitutions and we have the federal constitutions. That really complicates things for us. We live in a federalist system. We have 2 sovereigns. A federal sovereign, they control federal jurisdictional questions. And then we have state sovereignty that control internal issues related to the welfare and protection of internal questions within a state. It's very complicated and very difficult for people to sometimes digest this concept because it brings up questions whether federal law is going to apply or state law is going to apply. But the supreme law in any jurisdiction, if it's a state law question, the supreme law of the land would be the state constitution. Nothing can violate it. Nothing can be in contradiction of it. On the federal level, nothing can be in contradiction of the federal Constitution. Statutes, regulations in the federal scheme can't violate the federal Constitution, nor can state law and state constitutions violate federal law. Why? Something called the Supremacy Clause in the federal Constitution that says when in conflict, as long as the federal government has the authority to operate in that realm, they have jurisdiction, the federal government would be supreme. That's part of the big compromise when our country was formed. And most of us know that from high school and civics, and maybe it's just a little bit of a refresher for you. But we're not going to deal too much with constitutional law in business class or business law class. A little bit, we'll touch on it in a few areas. But for the most part, you just need to know the hierarchy of law. It's the highest form of law. It's the constitutions. And then the next, which I think of as very significant, is statutory law. This is where our legislatures, both on the state level and the federal level, create laws based upon governing society so we can live in a peaceful, harmonious, and maybe fair. It's not always about fairness, but I'd like to think it is, to create a society that's just. And we have significant statutory authority both in business law and in other realms of the legal system. The one that's actually the biggest for business law, and I always called it the Rodney Dangerfield of law, is called regulations. Because the complexity of the nature of how business operates, there's been a clear recognition that we had to create basically agencies to go out and create rules, which we call regulations, to guide us in different areas. We don't expect Congress to really be experts in food and drug policy. We don't expect them to be experts in flight safety or the like, all those technical things, highway, what should a tractor trailer truck be designed with in terms of the length of their mud flaps, or how long perhaps a trucker should be allowed to drive before they need to be off the road to get rest. These kind of complicated questions really need to be delegated. And that's when administrative agencies get created by the legislature to create rules that deal with those problems. And those are the things you're probably going to deal with in a business existence more than anything else are regulations. They are massive, they are very, very comprehensive, and they are the heart and soul of what I think governs the nitty-gritty of business. I think of my sister, for example, one time. She had owned a bar a long time ago, and there's all kinds of rules with the Alcohol Beverage Commission on how bars need to not only purchase alcohol, but serving requirements and the like. And it can be very, very complex. The next source of law is judicial decisions, which I've already referenced. That's the common law. Sometimes people don't like this, the fact that judges get to make law. That's not what the role is. They're supposed to interpret law. But by the very nature of existing as an appellate court, they create law. They interpret what a legal standard is, what it means, how it should be applied. And from that ruling, we craft a precedent. And that precedent will be followed in like cases in the future. That, in effect, is creating law. It is the weakest form of law unless it's interpreting the Constitution. Because think about it, if the Supreme Court of the United States interprets the Constitution to mean a certain thing, that's what the Constitution now means. So it gives the court a very strong area of legal creation, if you will, when it interprets the Constitution. But it's actually the weakest form of law when it's interpreting a statute or a regulation, because if our legislators don't like how the court interpreted that, or they think it needs to be modified, the legislature can rewrite the statute, long as it wasn't ruled unconstitutional. But they can rewrite the statute or regulation for more clarity in contradiction of the court. A lot of people are surprised by that. It's only when the court interprets the Constitution that we really, really tend to abide by it and live with it, unless we're willing to amend the United States Constitution or the state constitution, which is a very, very difficult task and rarely done. So those are the four major sources of law. Very summary form, very basic. There is a section of the book comparing civil law to criminal law, which is a fun little section to go through. Civil law are those, or civil lawsuits are based upon private wrongs and duties between individuals, and between an individual and a company, or between two different companies. These are deemed to be private nature to the individuals involved. The law has to recognize what's called a cause of action, a right to sue, to complain, because not every wrong that we feel like we've been dealt with in life is always actionable. You don't always have a right to sue for things that you think you've been harmed by. So the law first needs to recognize a civil right of redress or claim, and then you sue that other individual or company. These are private wrongs. The standard of proof, the plaintiff is the one that says, hey, I've been wronged by this other party. Maybe they breached a contract. I have damages, so I want to sue. The plaintiff, the party bringing the claim, has the burden of proof. They have to prove by a preponderance of the evidence that it's more probable that the facts as alleged are true and that they meet the legal standard to recover. In civil cases, you don't always have a right to a jury trial. In most situations you do. The Seventh Amendment to the United States Constitution says that you will have a right to a jury trial in civil matters if they were recognized at the creation at the time of the Constitution and the claim is worth more than $20. So the great vast majority of civil cases do have the right to have an impaneled jury trial, but they don't have to be unanimous when they make their decision. That surprises a lot of people. In some jurisdictions, all you have to have is a mere majority. In some jurisdictions, you have to have a super majority. If it's a 12-person jury trial, you might have to have 10 out of 12, 8 out of 12. In Massachusetts, it's just a simple majority. So if you have a 12-person jury trial, 7 out of the 12 have to render a verdict in favor of the plaintiff because they met their burden of proof by preponderance of the evidence, more likely than not that the facts have been established by them. That surprised a lot of people. I think it has to be a unanimous decision. In our system, which is more about Chapter 2, there's also district court jury trials. They tend to be 6-person jury trials, and the same principle applies. That's very different than criminal. In criminal law, it is not really about a private wrong, although an individual may have private harms, and obviously being a victim of a crime is very serious. I'm not trying to suggest that diminution of that in any way. What I'm trying to suggest is crimes are thought of as deeming harming society as a whole. They are detrimental to all of us in the community, even though we might not be the direct victim. We all are. We're all victims of criminal behavior, is the argument. So that's the difference. I do a lot of criminal defense work still to this day. Occasionally I'll get somebody who's the victim of the crime and they were friendly with the defendant, and they'll contact me and say, hey, I want the case dismissed against my boyfriend or my brother or my buddy. And so how do we do it? And I'll say, well, you have a lot of input as the direct victim of a case, but it's not you versus Jane Doe or John Doe. It's the Commonwealth versus that individual. And on the federal level, it would be the U.S. versus that individual. Victims do have a lot of say in the outcome of a case, but it is the government that brings the action in a criminal case as opposed to a private individual. There's the distinction between criminal and civil. The other is that there's a presumption of innocence for the defendant in a criminal case, and that presumption stays with the defendant until and if the government can prove beyond a reasonable doubt, very high degree of proof as opposed to just a preponderance of the evidence, that the defendant did commit the criminal act. It's a very difficult thing to define proof beyond a reasonable doubt. In Massachusetts, it's called the having an abiding conviction to a moral certitude that the defendant did the acts as alleged. That sounds good, but still very difficult to interpret. I like the definition where it's that degree of proof that leaves you without hesitation to draw a conclusion that the defendant did the act. Still difficult to actually apply, but for purposes of this course and for really purposes of life, you have to have a strong degree of certainty that the defendant did the act as alleged, or they must be acquitted. They must be found not guilty. That's different. So all you have to believe is, it's likely that the plaintiff has met their burden and they will win the case. The other distinction in a criminal case, if you can't afford an attorney, the government will appoint one for you. And you always have a right to a jury trial in a criminal case. And you also have different rights about having procedural safeguards, because it's the government trying to take away either your money through fines or property through forfeiture, or most importantly, potentially taking away your liberty. So we put these safeguards in place to make sure that it's done with hopefully integrity, and hopefully most of the circumstances they get it right. The other difference between civil and criminal in many jurisdictions is criminal juries must be unanimous. And recently the Supreme Court of the United States said on certain other states that weren't having unanimous requirements, it's now universal. Anyone being charged with a crime must be convicted with a unanimous verdict. It's also true of being found not guilty. If the jury falls somewhere in between and you can't get a unanimous verdict for either guilty or not guilty, it's a hung jury and the case is usually dismissed only to be rebrought and tried again. It's not double jeopardy because the person never had a conclusion to the case. I'm getting a little bit too deep in criminal law, but I'm just trying to draw distinctions between criminal law and civil law. And the other, most of the time in civil law, you're either asking for some kind of monetary damages, the return of property, or forbidding future behavior that was happening in the past. Criminal, it's usually sanctioning through fines or incarceration or putting someone on probation, which is a form of restraint of liberty in some fashion. So that's a big difference between the two. The book gets into the distinction between the seriousness of crimes. I guess you might want to know this for business. If you're either going to be an employee, you might want to know, geez, do I have a conviction, or do I have a record for felony? Do I have a record for misdemeanor? And if you're going to be somebody out hiring people, you might draw that distinction for your own hiring practices. Do I want people who maybe had some brushes with the law for minor offenses called misdemeanors, or would I consider maybe not hiring people who have serious criminal offenses on the record? Those are called felonies. How do we distinguish it? Different jurisdictions have different rules. For purposes of the exam, felonies are more serious crimes that are likely to get more serious punishment. It's obvious. You guys all know that already. But if you're curious in Massachusetts, I'm certainly not going to test you on it. The distinction there is a misdemeanor is anything that can be punished by no more than 2.5 years in the House of Correction, where a felony is anything punishable by a year or more to state prison. Kind of complex and a little bit, seems inconsistent because it can be actually a lesser sentence potentially for a felony. It's where you go, though. The book calls a case, it talks about a wobbler. I've never heard of that, but I think what they're getting into is sometimes a case can be tried either as a misdemeanor or as a felony at the election of the district attorney. The book gets in there, talks about who the district attorney is or who the prosecutors are, who the defense attorneys are, who the judges are, and how they become judges. It's kind of interesting, but I don't want to take this video too long, and I think the book is very clear on that. I do want to spend a little time on ethics. Ethics, I think, are very important. Hopefully you do too. It's, behaving appropriately in the right circumstances under a broad set of equitable beliefs. It's not always so easy to define what is ethical and unethical, and some of us will have different standards than others. And not to sound, jaded or harsh, but if something is not embodied in the law and somebody's done you wrong and behaved very unethically and immorally, what can you do with law? If it's not embodied in the law, you can't go to court and say someone's been very unethical to me. You have to point to a statute, a regulation, a common law principle that was developed by the courts that allows you to seek action against another party. It's pretty interesting how there's a distinction between that. And we do, I think many of you are business majors will either have to or you take it as an elective, and that's business ethics. I think it's very important. I want everyone to be ethical and try to be fair in their dealings with other people. But if it's not embodied in the law, ethics are something that's going to hopefully guide you in your behavior, but it's not going to be accessible and applicable in a court of law. You have to have a law. And most of our laws are rooted in ethics, but not all ethical standards are in the law, and not all of us agree on what is ethical and unethical. So it's a much broader spectrum of appropriate behavior. And we're going to have very different interpretations about what that might mean as a society. I think that kind of wraps up Chapter 1 as a nutshell. I thought I'd be much shorter than this. I was going to try to keep it under 10 minutes. It's 22. I'll try to be tighter in the future. This whole video thing is new to me, and I'm very uncomfortable in front of the camera, so I apologize. But if this video elicits any questions, shoot me an email. I'll try to get back to you in a reasonable period of time. I know the first assignment's not due until June 14th, so that gives us a little leeway, but I want to get up all 4 chapters before, much before June 14th. I'll probably have a second one up either tonight or the next day or two. I'll try to get all 4 in, certainly before the 6th or 7th of June. But don't be afraid to stay in touch and ask questions about either what you saw in this little video or what you're reading in the book. I hope my tests are very straightforward. Some of you are looking for the quiz, and I'm getting emails about that already. Not to panic. It's there. It's hidden from you. I don't want you to take it prior to the videos being up on all 4 chapters and really the bulk of the class having the book and read through it and try to do the homework assignments. Otherwise, be safe, be healthy, and we'll have our next video posted shortly. Thanks.